In our last video, Could Handguns Be Banned in Oklahoma? We presented several issues that have rendered useless the protections for the right to keep and bear arms in our state constitution. Between the progressive influence on the wording of Article 2, Section 26 of the Oklahoma State Constitution, our state version of the Second Amendment, and the progressive bias of our state appellate courts, virtually any restrictions on the right to keep and bear arms can, will, and have been upheld. For example, the Court of Criminal Appeals has said that the legislature could completely ban the possession and ownership of handguns in Oklahoma. Yes, this is Oklahoma, so it's unlikely that would ever happen. Or is it? 20 years ago, gun owners in Colorado would have said the same thing about their state. But with an influx of West Coast progressives who now control Denver and Boulder, Colorado is not so gun-friendly anymore. So what can we do to keep that from happening in Oklahoma? OK2A has been working for nearly 6 years with several legal experts and legislators to write an amendment to the state constitution that would establish much stronger protections for the right to keep and bear arms at the state level. Let's look at the elements of the proposed amendment and talk about what it does do and what it does not do. It says the following: the fundamental right of each individual citizen to keep and to bear arms, including handguns, rifles, shotguns, non-lethal defensive weapons, and other arms in common use, as well as ammunition and the components of arms and ammunition, for security, self-defense, lawful hunting and recreation, in aid of the civil power when thereunto lawfully summoned, or for any other legitimate purpose, shall not be infringed. Any regulation of this right shall be subject to strict scrutiny. The fundamental right. Under our current constitutional language, self-defense is not recognized as a fundamental right. In fact, the courts have treated it as anything but a fundamental right. They've treated it as a privilege that can be taken away on a whim. It is critical that our state recognize the fundamental nature of the right, that it exists in spite of government, not because of government. The right belongs to each individual citizen. It's not a collective right, it's not a militia right, it is the fundamental right which belongs to each citizen individually. The right to keep and bear arms specifically includes handguns, rifles, shotguns, non-lethal defensive weapons, and other arms in common use, as well as ammunition and the components of arms and ammunition. In denying the fundamental nature of the right, our state courts have said the right does not belong to the individual but to the militia, and therefore arms suitable for self-defense are not covered, such as handguns. This makes it clear, however, that it is your right and my right, that it's our natural right, that it's a right that predates government, a right to defend our lives with whatever means we have at our disposal. The right to keep and bear arms applies to security, self-defense, lawful hunting, recreation, and to aid the civil power when thereunto lawfully summoned. We have been very specific in what is covered. Everything. Security, self-defense, they're covered. Hunting is covered. Recreation is covered. And the militia aspect is covered. Finally, strict scrutiny is required by the courts. We'll come back to that in a moment. Finally, the proposed amendment also states, no law shall impose registration or special taxation upon the keeping of arms, including the acquisition, ownership, possession, or transfer of arms, ammunition, or the components of arms or ammunition. Now back to strict scrutiny. Strict scrutiny would be required by the courts anytime they look at restrictions of the right to keep and bear arms. There are three basic levels of scrutiny used by the courts. The first is rational basis. At this level, the burden of proof is on the individual. You have to prove the government has wronged you in some way. Next is intermediate. At this level, the burden of proof shifts to the government. The government has to prove that they have a legitimate need for the restriction in question. Finally, strict scrutiny. At that level, the government not only has to prove there's a legitimate need for the restriction, but there is no less restrictive way to accomplish the goal of the restriction. Generally, the courts have used strict scrutiny, or at least intermediate scrutiny, to review laws pertaining to fundamental rights. Our state courts, however, have applied that weak scrutiny, rational basis scrutiny, to firearms law, and this is just unacceptable. If adopted, our proposed amendment would force state courts to recognize the right to keep and bear arms as a fundamental and an individual right. This would give Oklahomans a second layer of defense against draconian gun control laws. A ban on so-called assault weapons, a magazine capacity limit law, or even an outright ban on the possession of handguns. All of these would be upheld by the state courts currently, but they would be overturned under the proposed amendment because of the requirement to employ strict scrutiny. So what would OK2A's proposed amendment do? It would provide stronger protections for the fundamental, the natural right of the individual to defend themselves. Now let's talk about a couple of things that it would not do. It would not infringe on private property rights. Your property is your property. You should have the ability to decide who is there and under what conditions they can be there. The chambers of commerce, both in Oklahoma City and Tulsa and the state chamber, are misleading many to believe that they would not be able to have a no-gun policy on their private property if they chose to do so. This is simply not true. We respect the rights of property owners to do with their property as they see fit. If I don't like their firearms policy, I can just go elsewhere. But it's their property. They can do with it what they want to do. So again, this amendment will not affect the ability of a property owner to set whatever weapons policy they choose. This and the Second Amendment are a restriction on government, not private individuals. This also includes private events held at public venues. Any event organizer that leases a venue has legal control of that venue during the term of their lease. Therefore, they set the weapons policy just as they would if they owned the venue, because for the term of the lease, in a sense, they do own it. Now, the second and more egregious attempt to mislead people. If this amendment is adopted, the Oklahoma City Thunder will have to leave Oklahoma City. Clay Bennett, Mayor Mick Cornett, and all of the rest, those spreading this blatant lie, should be ashamed of themselves. The phrases that Mr. Bennett and Mayor Cornett seem to think will force the Thunder to leave because the NBA requires a no-gun policy in their games are fundamental, shall not be infringed, and strict scrutiny. Basically all of the really important parts. Well, in 2012, Louisiana adopted an amendment to their state constitution that included all of these phrases. Why do I bring this up? Because the Pelicans, an NBA franchise, are still in New Orleans 4 years later. The Pelicans didn't have to leave Louisiana, so why would the Thunder have to leave Oklahoma? They wouldn't. This is just another blatant attempt, an example of both Mr. Bennett's and Mayor Cornett's anti-gun leanings. They have sided with Michael Bloomberg as he fights against your right to keep and bear arms. That's right, your favorite New York gun grabber is backing the efforts to keep you from having an opportunity to vote on this amendment. Proposed amendments to the Constitution go to a vote of the people. But Bloomberg, Bennett, Mayor Cornett, and the Oklahoma City Thunder, OKC, Tulsa Chambers, the Oklahoma Chamber, OSBI, all of these people have joined forces with David Boren and Michael Bloomberg to keep you from having the opportunity to vote for this amendment. We expect this from David Boren. He sits on the advisory board for Bloomberg's Everytown for Gun Safety. Plus, he routinely uses your tax dollars to lobby the legislature against your rights, as does OSBI and others. And the legislature listens. Gun owners in Oklahoma must get involved so we can send Bloomberg back to New York and tell his cronies here in Oklahoma that we will not tolerate having our natural rights trampled. To learn more about what you can do to help get this amendment on the ballot, visit us online at www.ok2a-action.org. That's www.ok2a-action.org.